I have given permission to the Minister for Health and Social Care to make a statement about the Dr Ranson case. Before I invite the Minister to make a statement, I would like to explain how I intend to operate the sub judice principle today. My understanding is that within the Equality and Employment Tribunal case of Dr Ranson v the Department of Health and Social Care, the only matter which could be said to be sub judice is the issue of remedy. A decision on remedy was given by the Tribunal on the 2nd of May, and the time to appeal this decision has not yet expired. I understand that having delivered its remedy judgment, the proceedings before the Tribunal are now substantively complete. Any appeal in respect to those proceedings will be considered by the High Court, a forum less likely than the Tribunal to be influenced by public comment. The rule of law requires that commentary on live cases outside the legal process be limited. On the other hand, the democratic process requires that the legislator be allowed to consider matters which are of concern to the public. It is my role as presiding officer to balance these competing principles. I am allowing the Minister to make a statement today because, in my view, there is significant public interest in Tynwald being able to discuss the Ranson case at this time. And because, in my view, the risk of any Tynwald discussion interfering with the remaining stages of the legal process is very low. Nevertheless, there are some limits. Firstly, I will not allow members to debate the quantum or the sum of money to be paid to Dr Ranson. That matter is clearly still before the Tribunal and liable to appeal. Secondly, in looking back at the early stages of the Tribunal case and the associated High Court proceedings, I will not allow any member to use their position in Tynwald as a platform to advocate or canvass support for anything they think the High Court or the Tribunal should or should not have done. The Minister can explain the position taken by his department at each stage of the litigation, but he cannot ask Tynwald to take a view on whether any decision made by the judiciary was right or wrong. I call on the Sheveshak Slant Krail Atia.
Dr. Ranson. Echoing the Chief Minister in the House of Keys last week, I would like to begin my remarks by offering a sincere apology to Dr Ranson on behalf of the Department of Health and Social Care for the way that she was treated by the department. I also wish to underline at the outset a point which has been made on a number of occasions previously, namely that the department fully accepts the liability decision of the 11th of May 2022 and has not at any time sought to go behind it. The liability decision raised a number of queries around disclosure which necessitated further inquiry, but there would always have been a hearing around remedy irrespective of these concerns, and I will cover both of these points further on. These proceedings, the disclosure and then the remedy hearings, were conducted within the parameters which were set quite clearly by the original liability decision, and the Department has fully respected them throughout. Honourable members are well aware of the level of public interest that these proceedings have attracted, and that as the DHSC Minister I have been unable to talk publicly in any detail about the Department's involvement in them. I can assure this Honourable Court that these constraints have left me as frustrated as you have no doubt been. Although the time for appealing the quantum decision has not yet expired, I think that it is important to use this opportunity to place on record the approach the Department has taken since the liability decision was issued in May 2022. I also want to use this opportunity to confirm to Honourable Members that the Department will not be seeking to lodge an appeal to the High Court. The Department would like to thank the Tribunal for their balanced consideration throughout the remedy process. I can also confirm that the Department has put the necessary steps in place with Treasury to process the payment due to Dr Ranson and has made a proactive approach to her legal representatives in relation to the costs award in an effort to expedite satisfactory resolution. Honourable Members, it is clear that an enormous amount has occurred over the past 2 years since April 2021 when this employment case was first filed, and there is no way in which this statement can adequately cover all the events in sufficient detail. Accordingly, I shall focus my comments today on events since the liability judgment was published last year and do not seek to cover the liability hearing or the matters leading up to in any detail, save for factors which are relevant to the remedy hearing. The failings during the earlier stage of the litigation have been aired publicly by the tribunal in both its substantive judgments and on a more routine level, as many of the key decision makers are no longer in post, and I wasn't around for the majority of this element. There is a practical obstacle in the way of me explaining these events with the same degree of confidence. Similarly, Mr. President, my comments are not intended to be a comprehensive response to other public statements or comments which honourable members may have heard, so they should not be viewed as such. This statement may not cover everything honourable members may wish to know, and I am happy to take questions and to try and answer them to the best of my ability. I intend to focus my statement around four main areas: the potential to settle the claim together with the final quantum, issues around disclosure including the ex-poll investigation, the appeals to the High Court, and finally some reflections on the overall conduct of the case since May 2022. Turning to settlement, the question of settlement. What I am in a position to confirm is there were attempts prior to the remedy hearing in January 2023 to try and resolve the matter. I can confirm that as well as being dealt with via correspondence, a meeting was held with the intention of trying to reach a settlement. However, as is now evident, this was not possible. When thinking about settlement, it is worth outlining how any sum of money would be calculated and the challenges this laid down in being able to negotiate a settlement. The core element of any remedy would be tied to the annual salary amount being claimed. Until only a few days before the remedy hearing, Dr Ranson's claim was for an annual salary of £350,000, which represented a 75% increase on her previous salary. On the 11th of January 2023, the claim was reduced to £229,000 per annum, which was still £29,000 more than the tribunal finally awarded. In purely financial terms, the difference between these figures is significant. Had the original position put forward been accepted, the final gross award would have been over double, at over £7 million, rather than the £2.5 million that the tribunal ultimately determined was appropriate. I'm sure honourable members can see the difficulty inherent in reaching a settlement when the amount being sought was so high in comparison to what the tribunal finally determined was a fair level of compensation, which ultimately was much closer to what the department viewed as reasonable and what its legal advice clearly stated. Mr. President, for the avoidance of doubt, the argument was not about the principle of whether Dr Ranson was entitled to compensation. Following the liability decision in May 2022, it was always accepted by the department that a payment would need to be made for financial and non-financial losses. It was also always understood the award was likely to be significant, and indeed the department's view, as submitted to the tribunal, was the eventual total would be in the region of where the tribunal eventually ended up. Turning to the appeals, there has been considerable comment made about the two appeals to the High Court last year. From the outset, I want to emphasise that neither appeal was against the original liability judgment, which the department accepted and has never challenged. Both appeals were against actions taken by the tribunal and were not in any way appeals aimed at Dr Ranson. Turning to the first appeal, which was primarily on the issue of legal privilege, I will try and outline some context from the department's perspective, noting of course that I was not in post as Minister at the relevant time, which limits my ability to fully explain the thinking around any final decision making. Due to the nature of the appeal, and in particular the focus on evidence being sought from an individual within the Attorney General's chambers regarding the issue of disclosure, it was considered that chambers were now conflicted. From that point, it was necessary to seek external legal advice, and Calvin Wilde were instructed. It is a complex picture, but ultimately, the purpose of the first appeal was twofold. Firstly, and at the outset primarily, to put beyond doubt that the tribunal should not be able to require a legal representative to waive legal professional privilege, and secondly, to question whether, as a matter of law, that individual was in any event the correct person to answer the questions which the tribunal had asked. Following the filing of the appeal, in their order of 1st September 2022, the tribunal confirmed they did not intend for legal professional privilege to be waived. As such, the sole remaining focus of this appeal was the question of whether the tribunal had been wrong as a matter of law to require the legal advisor to the department to give evidence for the purpose of enabling the tribunal to consider issues of quantum, disclosure or costs. Proceeding to have this issue settled by the High Court was very much a judgment call. The focus of public interest has been around this decision to proceed to court with the filing of the skeleton arguments on the 28th of September. I can confirm the decision to file the skeleton argument was made by officers in the department using powers properly delegated to officers from the Minister under the Government Departments Act 1987. The Minister, whilst being involved in correspondence around this decision, did not make a decision around filing the skeleton arguments, necessitating action being taken in his absence by those properly delegated by the Minister to do so. However, filing of the skeleton argument is not the same as deciding whether to withdraw from the appeal. Having filed the skeleton argument, there was still time before the hearing for a decision to be made on whether to continue with the appeal, and it was open to the Minister at any time in the following 8 days between filing the skeleton and the appeal hearing to withdraw the appeal should he have wished. As honourable members know, the appeal was not withdrawn, and this was a decision in the hands of the DHSC Minister. Following the conclusion of the appeal, there were no further inquiries from Dr Ranson's legal team for any further information from the Department's legal advisor beyond that which had already been provided. To this end, the appeal served its purpose. However, I accept the decision to proceed to court could be criticised as an unnecessary final step, and although I am not able to comment on why the then Minister chose not to withdraw from the appeal, I would caution against viewing things with 2020 hindsight. Now turning to the second appeal, which rather confusingly was heard before the first on the 26th of August 2022. This was much broader in scope and was lodged following concerns being raised as to whether the tribunal had stepped outside of its jurisdiction by embarking on an investigation into issues of disclosure. The key point being the tribunal's role following the liability decision was to receive from the parties any further evidence relevant to the remaining question of remedy and costs. There were real concerns that the tribunal was of its own volition undertaking an investigation into the adequacy of the disclosure process in order to, in their words, prevent a miscarriage of justice in any future case involving any government department. The view was taken that the tribunal had no such power to self-direct such an inquiry. It is the case that the High Court dismissed the appeal and concluded the tribunal had not stepped outside of their jurisdiction, albeit they were of the view the wording used by the tribunal was, and I quote, unfortunate. The High Court also made it clear there was no part of a tribunal's role to try and prevent miscarriages of justice in future cases. This High Court decision was set out in such a way as to emphasise what the scope of the tribunal's jurisdiction was, and explicitly linked the issue of disclosure to the outstanding issues of damages and costs. The benefit of this determination was twofold. Firstly, at the August 2020 disclosure hearing, the issues considered were properly limited to matters relating to costs and the overall quantum of the claim. But more importantly, the tribunal's remedy decision this month specifically referred to the outcome of this appeal, and that in his appeal judgment the First Deemster, and I quote, had cautioned against the tribunal taking on too much of an investigatory role. As an aside, and I shall come on to this next, the tribunal referenced this as their reason for caution in deciding not to use its own initiative to require the attendance of the authors of the Ex-Poll report for cross-examination. Although the tribunal did highlight it was open to either party to call Ex-Poll as witnesses for cross-examination, and noted that neither party chose to do this. Turning then to the disclosure hearings. The shortcomings in disclosure was a key feature during the liability part of the proceedings, and as honourable members know, the tribunal pulled no punches in its May 2022 decision. Subsequent to this, and following on from the short disclosure hearing in August 22, both parties agreed there was no need for a further disclosure hearing in November 22, and most of the disclosure issues which had previously been raised had apparently by that point been resolved. However, given the serious concerns raised during the liability process, the Department commissioned an independent investigation into the allegations of concoction of documents to be undertaken by two well-respected and established local companies, Ex-Poll and Riella Cybersecurity. Terms of reference for this investigation were shared with the tribunal and with Dr Ranson's team in July 2022, and the Department would have readily looked to amend them had any concerns regarding independence or scope been raised at the time. No such concerns were raised. The report was provided to the tribunal and all legal teams as soon as possible after it was received by the Department at the end of November 2022, and it was open to Dr Ranson's legal team to call whichever witnesses they wished, including Ex-Poll and Riella, to give evidence and be cross-examined under oath. They chose not to do so, and no evidence was presented to the tribunal to challenge the commissioning or outcomes from the report. The remedy decision summarises this position towards the end of the judgment, wherein it also states the tribunal's hope and expectation that the issue would have been tested and resolved. These points are important to make because of the conclusion which Ex-Poll reached. The allegations were that documents had been concocted. Ex-Poll concluded that there is no evidence whatsoever to support this allegation. The report did find that administrative errors had been made, which I don't believe should be surprising in the midst of an unprecedented global pandemic. But the independent investigation concluded there is no suspicion of criminality in the actions of those involved, and I must therefore conclude that the documents have not been concocted. I read these conclusions to reiterate that, as per the tribunal decision, the claimant did not set out any reasoned attack on the conclusions and gave no evidence to expand on her rejection of any of the conclusions. Lastly, Mr. President, I'd like to offer some reflections on the conduct of the case since May 2022. The publication of the remedy decision at the beginning of the month has rightly brought the whole matter to the forefront of public consciousness. As the Chief Minister outlined in another place, this government put in train a number of initiatives as soon as possible after the publication of the original liability decision a year ago, in May 2022. This month's decision restated many of the original critical comments in respect of the Department's handling of the liability decision, but also recognised the positive way the litigation has been conducted since that unchallenged liability decision. Given the significant difference between what was originally sought at £7 million and the amount of the final tribunal decision at £2.5 million, it is evident that the claim needed to be tested in the tribunal in order that the tribunal could come to an independent conclusion on all the evidence presented to it and arrive at a fair figure for compensation. However, just as important as testing the evidence is how this testing is done. The tribunal was clear there was nothing hectoring or untoward about the way the claimant was questioned by the Department's legal representative. And moreover, in its closing remarks, it commented that the tribunal would like to place on record their appreciation of the diligent input from both leading counsel as supported by their respective legal teams. The spirit of cooperation on administrative issues has led to the orderly process of the remedy hearing with the documentation in excellent order. Moreover, by way of some further context as to the approach taken by the Department, as noted by the Tribunal, the Department did offer an interim payment of £200,000, equivalent to a year's salary, on the 12th of October 2022. This was not as an alternative to final remedy, but rather to cushion Dr Ranson against lost income since January 22, and in recognition of the impact of the time the tribunal process was taking. Mr President, I've attempted to be as open and transparent as I can be with this Honourable Court, and I hope that I have explained to members in as fulsome a way as possible the actions of the Department in the months since the liability judgment last May. I am more than happy to try and answer any questions which Honourable members may have, but I have to say before doing so that no doubt, Mr President, you will help guide me and others on the issue of any remaining elements of sub judice. Birmayu Ekcharan.
Call on the honourable member, Mr Callister.
Thank you, Mr President. I thank the Minister for his statement this morning, very detailed, and obviously I think as members we'll need to take some time to reflect on what's been said this morning. But I just would like to ask the Minister one question, please. He mentioned then that when I was the Health Minister that officers acted under delegated powers. Can I ask the Minister how that delegated power was given and where it is recorded, please?
Minister to reply.
Thank you very much, Mr President. The delegated power in question was signed by Minister Callister on, I believe, the 22nd of December, and that document is, as far as I know, a publicly available document which I'm more than happy to circulate to honourable members.
Call on the honourable member, Mrs Christian.
Thank you, Mr President. Could the honourable member please confirm what date did the meeting occur in December, I believe he said, where they were seeking to offer a way through this without it having to go to court. Thank you, Mr President.
Minister to reply.
Thank you very much, Mr President. Unfortunately, the discussions around settlement were conducted on a without prejudice basis, so I'm not at liberty to talk in any detail about them, but I can confirm that it was after my reappointment to the department, so it will have been the back end of 2022.
Question, Mrs Christian, honourable member, Mrs Christian.
Thank you, Mr President. So you didn't actually meet, or you didn't arrange to meet in December the 2nd then, Minister? You didn't actually arrange to meet them on the 2nd of December. Can you confirm that, please, Mr President?
Minister to reply.
Thank you, Mr President. As I confirmed in my statement, there was a meeting that was held that I attended. I just can't go into any more detail around that without potentially having to break that without prejudice confidence, which, my understanding, I can't do that without Dr Ranson's permission. If Dr Ranson does give that permission, I'm more than happy to talk about the contents of those discussions in detail, but that is a joint privilege that I'm not at liberty to waive by myself. It would need consent of the other party.
Honourable member, Mrs Christian.
Thank you. So just for clarity, you say you met with them and you physically saw them? on the 2nd of December? Thank you, Mr President.
Minister to reply.
Thank you, Mr. President. I haven't given a date, Mr. President. I haven't even given a month. I'm trying to be quite careful because, like I say, this is a joint privilege. I can't talk in any detail. I'm at liberty to confirm there was a meeting that I attended. I can't really say any more than that without permission from Dr Ranson. I'm more than happy to go into detail, but I would need to seek confirmation of that from Dr Ranson and her team.
Call on the Honourable Member, Mr Callister.
And thank you, Mr President. Again, I would like to ask the Minister, just for clarity around this document that was signed in September, is the Minister actually talking about the roles and responsibilities that delegated down to members, or are we talking about the operational function that was assigned and to the Chief Executive Officer? Thank you.
Minister to reply.
Thank you, Mr. President. The delegation I'm talking about is the ministerial delegation that all ministers will sign when they take office, empowering officers to act in their stead when the minister is unavailable or unable to make a decision. Generally, the language is around in the minister's absence or unavailability. But as I said, I'm more than happy to circulate that document if that's the wish of the Honourable Court.
Call on the Honourable Member, Mr Callister.
Thank you, Mr President. Again, I need to push the Minister on what day and what time was I not available, because as far as I understand, I was available all the time during my time as the Minister.
Minister to reply.
Thank you very much, Mr. President. This is a difficult area for me to discuss, as I clearly wasn't present in the department. The Minister was involved in correspondence. There is clear documentary evidence of that. The Minister was corresponding with officers at the time in question. But as I said in my statement, during the relevant time, the Minister did not make a decision. That is, I think the Minister would support that statement that he, during the time, didn't make a decision. Unfortunately, a decision needed to be made in respect to filing. The way the delegations work is if the Minister isn't able to decide, he is not in a position to make a decision is made. What I would draw members' attention to is what I said in my statement around the filing of the skeleton arguments. That was not the end point. A decision to file the argument simply buys time. If no filing had been made, if the department had subsequently decided, yes, we want to proceed with the appeal, that would have been extremely difficult, if not impossible. The fact that the arguments were filed actually allowed 8 full days before the hearing for the department or the Minister to decide to withdraw from that appeal. So I am advised that in these cases it is up to the appellant, in this case the department or the Minister, to withdraw the appeal right up to the moment they hit the floor of court. So there were a full clear week in between the decision to file the skeleton argument and the appeal hearing date, at which, if the Minister wished to withdraw the appeal, he could have issued that instruction at any time in that week. As far as I'm aware, there was no such instruction issued, which indicates that a decision had been made to proceed with the appeal.
Call on the Honourable Member, Mr Callister.
Thank you, Mr President. Again, I'm going to keep pushing the Minister on this. The Department's minutes very clearly record that the Department was after remedy and settlement. That's what the argument said. I wish to put on record at no point was I advised legally or by officers that the skeleton argument could be withdrawn within the 8 days. And again, just put on the record, in respect to the Minister's comments here, the Minister is very fully aware of the events that happened on the 28th of September and the conversations I had with the Chief Minister, the Deputy Chief Minister, and with officers within the department. The direction was very clear. I think some of the information given by the Minister this morning is not factually correct, and I will need to take some advice from yourself and others, Mr President.
Did you wish to respond?
Thank you, Mr President. Just for the avoidance of doubt, Mr President, I'm not aware of the contents of conversations the Honourable Member had with others. I was not present. I can only report on the facts as they are presented to me. The legal situation, as has been explained to me following me asking for some clarity, is that appeal could have been withdrawn right up to the point they hit the court floor. So that option was always open and has always been open at any point. As to what decisions were made by the department, I think it is evident from the information that has already been released under Freedom of Information and through other mechanisms that there was no clear decision made at any point by the department as a whole during that period. There were conflicting opinions between department members and the Minister. Obviously, there must have been other conversations that I wasn't party to. I accept and acknowledge that. All I can state are the facts as I have in front of me, Mr President, which is the arguments were filed by officers using delegated powers properly given to them by Minister Callister at the time, and it was up to the Minister in the succeeding 7 or 8 days, I believe, to withdraw that appeal if that had been his direction of travel.
The Honourable Member, Mr Callister.
Thank you, Mr President. I therefore ask the Minister, will he be publishing a copy of the minutes and relevant papers? And I need to take guidance from the court here, Mr President. Obviously, I'm a Tynwald member here. I'm restricted about what I can actually say because a committee of Tynwald has restricted the evidence that I initially provided. When will I be able to release that information in order to give a proper, clear insight to the public about what actually happened in the events in September and October?
I'll call on the Minister to reply first on the minute-ish question.
Thank you, Mr President. My understanding is the minutes the member is referring to were in fact notes of a meeting rather than formal minutes that the Minister himself had rewritten. So I'm not entirely sure whether they can be released. I'm more than happy to talk to officers and see whether that's possible. I have no problem at all sharing the information that I have available to me. The point that I've tried to drive home is the decision-making around the skeleton on that day, on the Wednesday, is not the critical point. The critical point at which a decision could have been made is in the following week, at any point during that decision. At any point during that week, sorry. The Minister was adamant that he did not want to proceed with the appeal. He could have instructed officers, he could have sought legal advice, and they could have approached the court and asked for permission to withdraw that appeal. That was an option open to them in that week. That didn't happen. We all know that didn't happen. We all know the appeal proceeded. And as I said in my statement, I'm not in a position to comment on why no decision was taken to withdraw. That really isn't something I feel comfortable talking about. I don't think it's right for me to try and second-guess other honourable members and the decisions they had to make. As to the committee and other questions, I'm not in a position to answer that, Mr President.
Call on the Honourable Member, Mrs Christian.
Thank you. The Minister's just spoken about how the Honourable Member, Mr Callister, had time to remove the appeal. Obviously, that was something that he was unaware of. Could the Minister confirm, did the paper actually ever get to Coman? And if it did not, was that a decision that the DHSC made? Was it withdrawn? And could he confirm, if it did get to Coman, did they ever get a response as to how they should proceed? Thank you.
Minister to reply.
Thank you, Mr President. I think the Chief Minister has already answered that question, and I think that information has been published already as part of Freedom of Information responses. I'll have to check. I mean, from my perspective, I have no issue sharing the information that I have. I've said that a number of times. I need to seek permission from Council as to whether I'm allowed to share that paper. It is a Council paper, so it's protected by Council Ministers' Act rules. I'm happy to share what I have, but again, as far as I'm aware and as I'm advised, this is a decision that was entirely in the hands of the department. I should know, Mr President, I've been here now for nearly 2 years and I've been asked to make very similar decisions myself. I know the decision rests with the Minister. Whatever advice the Minister chooses to take, whichever advice he heeds, all that can ever be is advice. Ultimately, the decision rests with the person sitting in this chair. That is the nature of the beast. The fact remains that there was that period of time to withdraw, so if the Minister was opposed to proceeding with the appeal, he simply had to say so. He simply had to instruct his officers and ask the question, is there a way of withdrawing, at which point he would have been given the same advice that I was given, which is, yes, you can withdraw the appeal up until the point you start to make your case on the floor of the court. So the critical period of time is not around the Tuesday, Wednesday, where the papers were going to Council or back, or the decision-making process. That isn't that critical. The critical period is the week following that filing of the argument, at which point a decision could have been made in good time without any rush or pressure. There would have been a full 7 days to consider whether or not that appeal should have indeed proceeded to court. As I've said a number of times, I'm not in a position to try and understand why that decision was made. As I said in my statement, I would caution members, though, against looking back on this time with perfect hindsight. It is a complex picture. It was very much a judgment call that was being made. I'm not sure I can honestly stand up here and tell you it was right or wrong. All I can try and do is lay out the facts as they are and allow members to come to their own conclusions.